You know, in days like this with the coronavirus going around, it's nice to have your own fort that you can retreat to. So that's where I am right now. This is our fort, Burnside's fort, only a mile away from our office. It's an original 1770 log fort, and it's a great place to escape the coronavirus, at least for now. And we even got gun ports in the walls, and it's not quite finished, but we're ready for, you know, whatever the world has to throw at us. So, you know, this is a time where people have been asking me questions about martial law, like what could happen here? What's the worst that could happen? You know, in our history, there have been all sorts of instances of things kind of like martial law, or like what we would refer to as martial law, which have occurred. Written some of these down. Probably the most famous one, really the first one, was 1794, when George Washington raised a bunch of state militia troops and marched them to against American citizens to put down what was called the Whiskey Rebellion. Now, that's a worthy cause, but it did not survive George Washington basically marching state militia troops against them. So that was really the first time that this has happened. And, you know, fast forwarding some, in 1957, we had all these civil rights desegregation cases coming through. 1957, the governor of Arkansas deployed the Arkansas National Guard in Little Rock, and also President Eisenhower deployed military forces and asserted federal authority over the Arkansas National Guard there. 1962, President Kennedy deployed the military to Oxford, Mississippi, to attempt to control rioting that was occurring during the court-ordered desegregation process in the schools there. In 1964, President Johnson, LBJ, sent the military into Alabama to assist with the court-ordered desegregation of schools there. Again, the year later, in 1965, LBJ again now deployed the Alabama National Guard to protect the Civil Rights March, which was taking place from Selma, Alabama, through to the capital of Alabama, Montgomery. So we're not done there. Actually, 1970, the famous Kent State case. So 1970, the Ohio National Guard was deployed in response to protests which were occurring at Kent State University. And I looked into that a little bit, and really the reasons that were given at the time is there was an FBI report that they had seen weapons among the protesters, though nothing specific, and that there was talk about burning things. And so they deploy the National Guard. You know, to make a long story short, by the end of the ordeal, I think it was May 4th, 1970, you had 28 National Guard soldiers who fired a total of 67 rounds over a period of 13 seconds, which ended up killing 4 students and wounding 9 others. So that was 1970. As Thomas Paine said very early on in the history of our country here, these are the times that try men's souls. The summer soldier and the sunshine patriot will in a crisis shrink from the service of their country, but he that stands by it now deserves the love and thanks of man and woman. Tyranny, like hell, is not easily conquered, yet we have this consolation with us, that the harder the conflict, the more glorious the triumph. What we obtain too cheap, we esteem too lightly. It is dearness only that gives everything its value. Heaven knows how to put a proper price upon its goods, and it would be strange indeed if so celestial an article as freedom should not be highly rated. Again, that was Thomas Paine from The Crisis. Now, as far as a couple case updates, I've been asked for a lot of updates. All right, the most recent one, our family court search case. Our client, Matt Gibson, I believe on Monday, filed a formal Judicial Investigation Commission complaint. He also filed a written motion to disqualify the judge that is observed, that is seen in the video, and we're going to let that take its course. I've been doing some more research since that time, and I'm still have been unable to find one other case in the country, much less in West Virginia, of this ever happening. I have found other instances already from information I've received, people who've called me, of this happening to other people in that very county, and I'm investigating that right now. But I haven't seen anywhere else in the state, any other family court jurisdiction in the state, any other state in the country where this has happened. There was a family court lawyer in that county who did sort of a rebuttal on the local TV news to my opinions about the search having a lot of problems. I didn't really feel it necessary to respond in detail to that. I didn't hear anything that changed my opinions. When you're discussing constitutional rights, it helps to discuss the Constitution. I don't really care what certain discovery rules say that may or may not apply to that case. Based on what I've seen, it doesn't appear to me that there was any justifiable basis for what you saw in that video. My opinion hasn't been changed. So I still don't see any legal justification for that. The Walker open carry case, we've officially filed a notice of appeal to the U.S. Fourth Circuit Court of Appeals, and this was as expected. So it's officially being appealed right now, and there are some important issues that we'll be facing. Does the presence of an AR-15 style rifle itself legally constitute what's known as reasonable suspicion that a crime has been committed? And that's important because it allows the police to stop you and Terry search you, get your ID, run your ID, things of that nature. So does an AR-15 as opposed to another type of firearm provide that justification just in and of itself? The other side, the opposition in that case, is asking for that sort of legal case law to come out of this case, which would be really, really unfortunate. Right now it doesn't exist, and that's been my argument from the beginning. Other issues we're going to see in that case, you know, are AR-15 style rifles commonly possessed for self-defense reasons? I thought that was pretty obvious, pretty self-explanatory, but that's become an issue in that case. So, you know, we'll see federal appellate judges probably discussing that. Does a person wearing camouflage pants, in addition to having an AR-15 style rifle, does that in and of itself constitute reasonable suspicion? Because, see, here's the thing. In that case, they were trying to say that my client, Michael Walker, since he had camouflage pants on, he had an AR-15 style rifle draped over his back, and he's walking down the side of the road. That's unusual, and there's a school off in that direction. Well, since the Parkland shooting in Florida had happened not even a month before that, you know, the police were allegedly worried about copycat crimes, and therefore that was reasonable suspicion. Now that wasn't a part of the facts at all, and you're looking at objective arguments here. So the police officer in that video was not visibly concerned about him being a school shooter at all. It's just something that was that the lawyers came up with after the fact. But here is the big thing that everyone's missing, and really has nothing to do with the facts of the case. The Parkland shooter, what do we know about him? He arrived to the Parkland school in Florida via an Uber. And did he have an open carry firearm of any sort on him at that time? No. He had a black duffel bag. Now, he had obviously an AR-15 style rifle in the black duffel bag. But what does that have to do with being worried about Michael Walker being a potential copycat criminal? You know, if he had asked an Uber driver to take him to the school and he had a black duffel bag and they had information to believe he had an AR-15 style rifle in the duffel bag, then yeah. I mean, that is a different factual scenario that was not present in the Michael Walker case. Most importantly in that case, US v. Black, from 2013, a Fourth Circuit case, be overruled. That's an important case. That's probably our best gun rights case that we have in the Fourth Circuit, which is Virginia, West Virginia, Maryland, North Carolina, South Carolina, West Virginia, if I didn't say that. But it says that you are basically free to open carry a firearm in an open carry state, such as West Virginia and North Carolina, and that the police can't stop you, harass you, background checks, Terry search you, just because you have a firearm, because the legislatures in those states have made the decision that they trust their citizens to openly carry firearms, or even to concealed carry firearms. So we're not going to let anybody, or let law enforcement assume that, well, you can suspect that they have committed a crime, that they're it's an unlawful firearm, that they're prohibited from possessing a firearm, or they may have committed a crime. No, because all of us citizens are allowed to open carry, unless you already have information specific to me that I'm not allowed to have one, then you can't harass me, you can't stop me. So that's a very important case. And it was already kind of neutered as it applies to people in vehicles and traffic stops. And that's the U.S. v. Robinson case from 2017, awful case. But now they're trying to do it to pedestrians. And it's important, not just for somebody in the specific circumstances, Michael Walker, but for all of us, because it's going to apply to all sorts of future circumstances in which we might find ourselves in. One example, and a big example, would be the recent Second Amendment rally in Richmond, Virginia. How many guys did you see in those photographs were open carrying, over their shoulder, AR-15 style rifles? If the court, or if the opposition in the Walker case were to get their way, that's the Fourth Circuit. So they would have the ability, the Governor Northam would have had the ability to order the state police to just Terry search all those guys, to disarm them, pat them down, get their ID, run their background checks, even if they had committed no crime, even if they had a firearm that was completely legal and they were open carrying, which was completely legal. So that's the connection there. It's not just, well, I wouldn't walk down the side of the road with an AR-15 like Michael Walker did. It's going to apply to all sorts of things. So that's going to be an important case. Putnam County seizure cases, so far we're ready to proceed on at least 6 different cases, all involving the same sort of facts, the same individuals. We've served additional Freedom of Information Act requests. We've only gotten, in all the paperwork that we've received, we've only got one of these cases that's substantiated by any paperwork. And in that case, there was no criminal conviction that resulted from it, and there's still enough problems with it. And there were 2 searches, and the first one was without a search warrant. So our investigation really has verified a lot of what we thought we knew. But there's still a lot more work to do, and as soon as we start filing suit in those cases, we'll have the ability to take depositions, to engage in discovery, and we'll learn a lot more. The crazy thing is they did this internal investigation, and we participated in that. I opened my files to the internal investigators. The sheriff of Putnam County reported to the television news station that he had ordered an internal investigation. But how many months has it been since then? Or how many weeks has it been since then? And nothing. I've specifically asked in writing and via FOIA request, what is the result of the internal investigation, which was employment related. Are these people suspended? Were they on administrative leave? Are they fired? Whatever. No response, nothing. And there's a lot of my clients, they're scared. They were scared to come forward. They still haven't come forward yet, some of them. Some of them are absolutely terrified. And there's no information being given whatsoever. And just the other day, I learned that one of those officers still has a badge and a gun because he arrested somebody. At least according to the reports that I received. Next case, the corrections employee traffic stop case. There was an internal investigation by the state in that case right away. The guy who performed the stop of my client was, as I was told, allowed to resign, which basically means that he was fired, as I understand it. There is a criminal investigation that is currently pending against him, but I've been told that he has declined to be interviewed at this point, and it doesn't look it's going to remain that way in the foreseeable future, as far as I know. So I reached out to the state to get their lawyers involved and to get their insurance company involved, and so they reached out to their insurance company, and I'm currently waiting to hear back from them. So, you know, we'll try to negotiate something here, but, you know, since this guy basically got fired or was allowed to resign and is under criminal investigation, you know, they very well may say that it's excluded from the insurance policy, and then we have to get into a more complicated case. So still give him a little more time to respond to me, and then we'll proceed with that. And there's new cases coming up, and even new videos and other cases that are kind of in the queue. So stay tuned. You know, in this time of, you know, we apparently got our first few coronavirus cases here in West Virginia, and one, apparently I just heard a little while ago, is fairly close, happened at the Greenbrier Resort, not far away at all, and is somewhat local. So, you know, I know people are scared. I'm not a big guy for poems, but I have one poem that I like. I have one favorite poem, and it's the only poem I know. And I have it hanging on the wall of my house. And I think I'll just kind of close with this, and it's a great thing to hear. This is just a portion of it, but it's called Desiderata by Max Ehrmann, 1927, which is Latin for things desired. Nurture strength of spirit to shield you in sudden misfortune, but do not digress, do not distress yourself with dark imaginings. Many fears are born of fatigue and loneliness, and whether or not it is clear to you, no doubt the universe is unfolding as it should. Therefore, be at peace with God, whatever you conceive him to be, and whatever your labors and aspirations in the noisy confusion of life, keep peace in your soul. With all its sham, drudgery, and broken dreams, it is still a beautiful world. Be cheerful, strive to be happy. Thanks for watching.